Assalamualaikum and a good day I bid to Madam Mazlina and to our classmate. We are going to present two articles, the current issue that related to the Malaysian industrial relations. Our group are choosing the current issues, which are the first industrial court and award and second is trade union. I am Nurul Ainnatul Shahhirah binti Zulkifli as first presenter, followed by Arie Adriana, Razzanah Qurratuaini, Siti Hajar and Nur Ain Sofea will be the last presenter. Let's move to the first article, which is the Industrial Court cite COVID-19 to deny wage revision in collective agreement dispute. Back on the issue, we are found that on this article, the Industrial Court on 26 November 2020 handed down an award refusing a union's claim for across-the-board 10% of salary increases, bonuses and other benefits with the reason of COVID-19 pandemic crisis. Usually, this issue will be questioned by many of employers because they have been pondering the impact of the COVID-19 pandemic on collective agreement dispute. In this case, the Industrial Court has recognized the impact of the COVID-19 pandemic on business and employers. Next, in Kesatuan Sekerja Industri Elektronik Wilayah Utara Semenanjung Malaysia and Panasonic Automotive System Malaysia Sdn Bhd has raised a trade dispute between the Northern Electronic Workers Union and Panasonic Automotive System Malaysia Sdn Bhd after a deadlock was reached in negotiation over a collective agreement. In the dispute, the union had demanded for a 10% across the board of salary adjustment, contractual bonus and a 10% annual increment to all eligible employees. The Industrial Court was not convinced by the union's argument and ruled as follows about no salary adjustment are to be awarded. Other than that, there is no contractual bonuses are to be awarded to them and the annual salary increment is fixed only at 5%. The union's position for its members were entitled to equitable rates of pay and other terms and conditions of service that the company is under moral obligations to provide. This is because the employees and their families are dependent on wage to provide them with the basic of necessities of life and given them the rise in the cost of living. The company took the approach that the employees were already being paid equitable rates of pay and this is requested by the union in the collective agreement were excessive and unreasonable. The company did not have the ability and the capacity to pay the higher wages when the business environment is becoming increasingly challenging. This was making it worse by the COVID-19 pandemic and the enforcement of the movement control order by the government, which contribute to the drastic decline in business. Therefore, the trade dispute was heard in the Industrial Court before a 3-member panel comprising the chairman of the Industrial Court, representative from the employers panel and representative from the employees panel. I will pass to the Arie Adriana to explain about the statutory law applicable in this issue.
Thank you, Ainnatul Shahhirah. So, I will explain on the statutory law of this case. As what have been mentioned by Ainnatul just now, collective agreement means an agreement in writing concluded between an employer and a trade union of employers, on the one hand a trade union of workmen of the other relating terms and conditions of employment, and work of workmen or concerning relations between such parties. Based on the case, the union demanded an amount of salary during movement control order due to COVID-19. In the said case, the Industrial Court has acknowledged the effect of the COVID-19 pandemic towards the businesses and employer, and this case has been brought to the Industrial Court and the decision have been met by the court. In coming to the decision, the Industrial Court has perceived the current challenging business environment, which has been worsened by the pandemic and the government enforcement of the MCO. So, the court has agreed that the factors have given to the drastic decline in business. It is also interesting to note that the court was prepared to take into account account the effect of the COVID-19 towards the business environment, even though there is no indication in the award that the employer had mentioned the evidence of financial hardships. This decision has received criticisms from the trade union, but they must take note that under Section 30, Subsection 4 of the Industrial Relations Act 1967, the Industrial Court is statutorily required to have regard to the public interest, the financial implications, and the effect of the award on the economy of the country, the industrial constant, and the probable effect in related or similar industries. The Industrial Court stated that this decision was based on the interests of the members of the union as well as the financial implications to the company. This was because of the fragile economic climate caused primarily by the COVID-19 pandemic. As uncertainties loom, the court wished to remain cautious in its decision with the interests of both parties in mind.
So for the next slide is compare and contrast the legal issue that we identified in this article that related with the syllabus. In examining the extent to which the industrial relation law and practice in Malaysia that we learn in the syllabus, we should compare the relevant law of the industrial relation with this case on the article to governing workers' right with the statutory law provision. In this issue, the key highlights of the Industrial Court decision are about the effective date and duration of the agreement. The union sought for the collective agreement to take effect from the date of 1 January 2018 so that the members can be entitled to get the benefit thereunder, such as areas for salary adjustment in 2018. For the first point, in the compare and contrast, the decision on this issue where the effective date of the collective agreement is on 1st July 2019, and it is because according to the section 30 subsection 7 of the Industrial Relations Act 1967 expressly provide that an award of the court cannot be retrospective to a date earlier than 6 months from the date on which the dispute was referred to the court. Second point is, according to the syllabus of the industrial relations on the effect of collective agreement under Section 17 of Industrial Relations Act and Section 32 subsection 1, a collective agreement which has been taken cognizance by the Industrial Court shall be deemed to be an award and shall be binding on the parties to the agreement, including in any case where a party is a trade union of employers or all members to whom the agreement relates and their successors, assignees of transfer.
However, in this issue, when the MTUC agreed that citing the COVID-19 circumstances can effect such awards during the pandemic, but the chairman failed to examine the documents to verify if the company had indeed suffered because of COVID-19. So, they advised the chairman should have included a clause in his written judgment requiring the management to go back to the union for renegotiation as soon as COVID-19 pandemic is controlled and business is back to normal. Therefore, in the syllabus also have stated that in collective agreement, there are some items to be considered where a clause which states that any current agreement will remain in force until a new agreement is signed. Next, the other things that need to be signed is supplementary memoranda with a covering letter stating that they are meant to be read together with the collective agreement. The collective agreement must be simple and unambiguous wording and also must be used language that can be understood. So, I will pass to Razzanah for the next case.
The second case is about trade union where government constantly changing CMCO work from home order confusing smacks of double standard. The issues are based on the article. The Secretary of MTUC Selangor and Federal Territories Division, Muhammad Faizal Hussein, represents the voice of nation workers who has criticised the government approach on introducing the policies to reduce the risk of COVID-19 infections spreading at the workplace. He represents as union on behalf of Malaysian workers for an estimated 800,000 workers in the private sector and 200,000 civil servants in management and supervisory positions in Kuala Lumpur, Selangor, Putrajaya, Sabah and Labuan are giving his thought on the government's order that required the employees to work from home until the end of the CMCO during that time. Even though he can understand the reasoning for the WFH regulation in those circumstances, it is intolerable to him about the arising issue of discrimination in practice by the government. He viewed this matter from the net result of the strategy. Seems that managing and supervisors' well-being and life are more important than those other workers. He believes that if the goal is to minimize the chances of spreading COVID-19, this type of discrimination should not be used in the first place. The MTUC argues that only companies should be allowed to reside in minimizing the numbers of workers physically present at the workplace, since the company or employers know better about the situation on the ground than the government. Another issue that has been arised by the MTUC is regarding the constantly changing of regulation by the government with the lack of clarification on the CMCO areas work from home guidelines, which makes both employees and management felt confused about how to enforce the government order. For example, subsequent changes to allow a limit of 10% of such workers to be present in the workplace were both ambiguous and difficult to obey in rush. Thus, the National Security Council and their ministers should bring their action together and must fix to one set of SOPs without going back and forth. This is because employers in industry and banks are considered as an essential service and they need specific protocols to obey, not vague regulations. The last issue is the new requirement for COVID-19 swab tests for the red zone area did not be clarified clearly within the provision until arising confusion among the companies to apply the regulations either for workplace in red zone or employees in the red zone or both. In the end, it is declared that it is only compulsory for foreign employees in the red zone, and Malaysia workers in the red zone were advised to voluntarily undergo such tests. Especially those who have no symptoms but are from red zone must undergo mandatory tests regularly at clinics mandated by SOSO and are paid by their employers. So for the statutory law, I will pass to Siti Hajar.
Hi, I am Siti Hajar. I will present for the statutory law applicable to our second issue. A Conditional Movement Control Order (CMCO) was announced by the PM on 1st May 2020, then enabling a wide range of economic sectors and business practices to function in strict compliance with government-specified health standard operating procedures, which starting from 4th May 2020. To a certain degree, the CMCO relaxed the National Movement Control Order, imposed from 18 March 2020 under the Prevention and Control of Infectious Disease Act 1988. Act 342, the PICD Act and Police Act 1967, pursuant to which the government released the PCID Act Regulation 2020, which defined the relevant regulation with regard to the restriction of movement for the period 18 March 2020 to 31st March 2020 at the time. Then, a new set regulation of PCID Act 1988, which is to measure within infected local area, number 5 Regulation 2020, has been released and will be implemented between 4th May 2020 to 12 May 2020. However, we believe that the legal position may keep changing and unavoidable to do so as fixed legal by the government, since it depends on the adjustment of the current situation in order to ensure the effectiveness as well the required improvement needed in guiding the business or economic sectors far ahead. So, the law has since been extended until currently due to an outbreak of COVID-19 is remain. We just hope that even though the legal position keep changing, it does not be implemented in rush by the National Security Council and the ministry who may involve. The government should consult first with stakeholders such as employers group like the Malaysian Employee Federation (MEF) and Workers Representative, which is the Malaysian Trade Union Congress (MTUC), before coming up with the new regulation, along with only enforce the legal after further consideration by both parties in order to avoid any related discrimination occur or companies face confusing on the double standard from the regulation that been set up. Furthermore, the PCID Act is focused on the things that have been mentioned by the MOHR, which has provided guidelines state that everyone else must stay at home and not go to work, except for those who provide essential service. Under Section 6, Subsection 1, 2 and 3, Section 11, Subsection 1 and 2, Section 29, subsection 1 and 2, Section 13 and Section 31, the Minister referred to the PCID Act as inter alia in has the power to declare places within and outside Malaysia as infected areas, make regulation for the prevention of infectious disease, exempt any human, entity, animal or pathogen from the provision of the PCID Act. In addition, make laws restricting the movement of people and objects, regulate sanitary condition and regulate quarantine station, detention, isolation and observation of persons suspected of infectious disease, cleaning and disinfection of premise and any other matters that may be necessary for the prevention and mitigation of infectious disease. This is a reason for the swab test need to be done by the related person within the workplace as mentioned in the article in order to protect the well-being of everyone from further infection. Besides, the Employment Insurance System Act 2017 enforcement on Social Security Organisation (SOCSO) are encouraged to be covered by the companies toward their employees. However, there is no provision in the PCID Act that gives the Minister the power to make laws to enforce liability of both civil and criminal, to control employers' payment of wages when the business unable to operate. If there is an issue regarding employees' wages under Section 18 of the Industrial Relations Act, the union may raise issue relating to the failure of employers to pay salaries as matter of business dispute if the dispute includes member of the union. Then, under Section 60A, subsection 2 of Employment Act 1955, employers have the right to instruct their employees to work when its work essential to life community, interruption of work which impossible to foresee or accident with an actual threaten with respect to the workplace depends on the current pandemic crisis.
Hi, I am Ain Sofea. Let's proceed to the compare and contrast for the second issue as further discussion related with our understanding between the law and what we has learned. First, Malaysia Trade Union Congress, or called as MTUC, is a trade union federation which registered under the Act of Society 1955 and they are legal to do any activities related to the trade union. It is the oldest national centre serving and representing the workers of Malaysia. MTUC was recognised as the voice of workers in Malaysia and also consulted by the government through the National Joint Labour Advisory Council. Then we may say that MTUC is being recognised under general recognition based on the previous discussion where the union is entitled to present general questions on the terms and conditions or any grievance or service on behalf of all workers, whether they are members of the trade union or not at any circumstance arise. This is the same situation be done by the MTUC representative in the article issue when he able to voice out his opinion on behalf of all Malaysian workers. Next, the PCID Act 1988 is a guideline referred by the companies and HR person in order to operate their business as complying to the government instruction. The Act is not a part of our syllabus but it is a must-know knowledge for us. The purpose of this Act is to keep the well-being of the people within the current new norm at the workplace and as a step to prevent the disease further spread. However, if there any mistreatment or dispute occur during this time by the employer, the employee still can refer to the Industrial Relations Department or let the trade union to be their representative. Moreover, we can see that the application of Section 16A subsection 2 of EA regarding the industry and accession service mentioned in the article towards industry and banking are aligned between the law and our syllabus, which the accession service within the private sector follow as in Industrial Relations Act consists of 9 industries. The employer within these 9 industries has the right to order employees to work as long the company followed the requirement by the government as mentioned in PCID Act. The employees who work within accession service never can refuse, but non-accession service like hotel or manufacturing can refuse to work, but it depends on the law as mentioned under Section 16A subsection 2. This current issue also can be related to the employer and employee's implied duties, the option that encourage the employer to cover employees also by providing financial assistance to employees due to the contracted a work related with the current disease of COVID-19. The scope covered all Malaysian employees who have not attained 60 years of age, except those who attain 55 years of age and have made no prior contribution before they reach the age of 55. By covering so for employee swab test, this shows it is the legal duty of the employer from an implied perspective to provide a safe working environment for the employee. Means if the employer fails to perform the implied duty, and the consequences of that is a breach of contract by the employer action. Then from the perspective of employees' implied duties is employees need to obey all lawful and reasonable orders as well as work with due care. This is when the employees need to follow employer instruction as mentioned on the PCID Act, since it is legal and should not refuse to do swab tests. It is a way for them to work with due care during this current pandemic as precautions. So if the employee does not comply with the legal as instructed by the government, such as failure to comply with MCO guidelines, the employees can raise the issue to the union, launch a police report or report this to RELA. The Royal Malaysian Police and RELA were named officers with powers under Section 3 of Prevention and Control of Infectious Disease Act. To sum up, the article covered the role of trade union, and one of the role of MTUC related to the article is to do everything to encourage the interests of its affiliated organisation, to enhance workers' economy and social condition, and to provide them with assistance. That's all from us. Thank you.